All right, court calls CR 2324, State versus Karen Sue Burton. We're set for evidentiary hearing today. Mr. Green. I saw Mr. Green, but I don't.
I'm here, Judge. I'm trying to get my video started.
There you go.
Judge, I'm not prepared to go forward today. I sent Mr. Abraham a message this morning that I've been home all day sick and still sick. Can you hear me, Judge?
Yes, yeah, I'm just listening.
Okay. So I just asked for another date.
State, are you prepared to go forward on the motion today?
Judge, the state filed a response to Mr. Green's motion. We don't believe that it provides us proper notice of what any alleged deficiencies. Appears to be a boilerplate motion. We would ask for some sort of notice as to what Mr. Green's alleged legal deficiencies with the case are. But we're not opposed to resetting to allow him time to file a motion that gives us that notice.
And Judge, I know Mr. Woodwick filed a motion in one of my other cases, but I don't recall seeing one in this one. Tyler, when did you file that? Do you remember? Or do you have
the 20th? I'll email you a copy of it, Mr. Green.
20th of April?
Yes, sir.
Yeah, I pulled her file up, electronic file up, and I don't have anything. I know y'all filed one on the one that's set next week in Judge Winter's court.
Okay. There's one on this too. I'll send it to you.
Okay.
But it sounds like we're not going to do anything on it today either way. So.
Okay.
All right, I do an evidentiary setting in May. So the next evidentiary setting I'll have will be June. Looks like it will be June 29th. So Ms. Burton, I'm going to set you to appear back before the court on June 29th. And that will be at, you have any scheduling conflicts for 9 a.m., Mr. Green?
No, Judge, that'll work.
All right, and the court's going to take up the state's motion and any response filed by Mr. Green with regards to the defendant's motion to suppress. I'll take that up without a hearing. So if you want to respond to that, Mr. Green, then send that in, and then I'm gonna make my ruling on it without a hearing.
Okay. Thank you, Judge.
All right, so I'm gonna have Ms. Burton sign a notice of appearance form with our reset date, and then she's going to be free to go. So if you're ready to go, you're free to go, Mr. Green.
Thank you, Judge.
You're welcome. Hope you feel better.
Thank you.
All right, Ms. Burton, the bailiff's going to bring you form to sign. You'll just sign where it says there's an X for defendant, and then we'll give you a copy of it, okay? All right, who do we have in the jail that's ready?
Got Mr. Rogers with Mr. Adams, Your Honor.
All right, court call CR 2191, Levi Rogers. For arraignment today, go ahead, Mr. Adams.
Thank you, Your Honor. On behalf of Mr. Rogers, he and I have reviewed the indictment together, and Mr. Rogers advises that his name is properly spelled, set forth in the indictment. that he understands the nature of the allegation made against him in the indictment, and that he enters a plea of not guilty, and we waive a formal reading of the indictment at this time. Request a pretrial setting.
All right, court will enter Mr. Rogers' plea of not guilty into the record, and will set this matter for pretrial hearing on June 15th, unless there's an objection to that date.
Your Honor, I do not know that this will go forward, but at present, I am set for jury trial in Federal District Court for the Eastern District of Texas on that date.
Let's try this then. We'll set for June 1st. Do you anticipate that Mr. Rogers may make bail on this case?
I do not believe so, Your Honor. I don't think you'll be able to do that.
Okay, if that's the case, then I do have a jail only setting on June 1st.
That will be fine, Your Honor. I have something set on that docket already as it is.
Okay, we'll set June 1st then. And that'll be for pretrial.
Yes, sir.
Sounds good. Thank you. Will do.
Your Honor, that's all the business I have before you this afternoon. My big excuse.
Yes, thank you, Mr. Adams.
Good to see you.
Your Honor, we have Mr. Brent Gamble ready with all three of his clients, not Adrian Gutierrez in the room. So I'm going to let you two choose who you want to speak to first.
All right, let's bring up Mr. Candela. CR 22-7, Jose Carlos Candela. And are we doing a Mr. Candela today, Mr. Gimble?
Yes, Your Honor.
All right, and State, can you give me the terms, or Mr. Gimble give me the terms of the plea?
Yes, Judge, let me pull it up real quick. Or Mr. Gimbel has the paperwork if he's got it right in front of him, but my computer's working on it.
2 years TDC, probated for 2 years, and restitution in the total amount of $6,479.39.
How many cents?
39.
39 cents. You said is that on?
It's a state jail, 2 years in state jail division, Judge.
Right, on, that's charged, that's a property, 2,500 to 30,000?
Yes, Judge.
All right, and what are the court costs?
Court costs are $290, $70 reimbursement fees, attorney's fees of $500, restitution of $6,479.39. I think that was stated already.
What about credit? Okay, it's not a to-do sentence, so no credit time.
No, Judge, it's a probation at this time.
Okay, all right, Mr. Candela, if you'll raise your right hand, I'm going to place you under oath. Mr. Candela, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I can't hear you, sir.
Yes.
Okay, make sure you speak up loudly and clearly. You can put your hand down. Mr. Candela, I have a court reporter here in the courtroom with me, and she's taking down everything that we say. You got to make sure you speak up loudly, okay?
Okay.
All right, Mr. Candela, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Brent Gimble. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to discuss your case with him and have all of your questions answered?
Yes.
Is there anything about the paperwork that you have signed and reviewed with Mr. Gimble today that you do not understand?
No.
Is it your true and correct signature that appears throughout the documents?
Yes.
Mr. Gimble, do you believe Mr. Candela to be competent today?
I believe he is, Your Honor.
And you've explained the paperwork, which includes his legal rights to him.
Yes, Your Honor.
And Mr. Candela, you heard Mr. Woodwike and Mr. Gimble disclose to me the proposed plea agreement. Is that your understanding of the plea, Mr. Candela?
Yes.
You understand that if I approve this, you will be convicted. You'll become a convicted felon today for the purposes of theft of property, $2,500 to $30,000, and that you'll receive a 2-year sentence, but that sentence would be suspended and you'd be placed on community supervision or probation. You understand that?
Yes.
And that's what you're asking the court to approve today?
Yes.
All right, then Mr. Candela, you need to know that the range of punishment for this charge, which is a state jail felony, is confinement in the Texas Department of Criminal Justice State Jail Division for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. The court finds that the proposed plea agreement would fall within the range of punishment. Do you understand the full range of punishment?
Yes.
Okay. Understanding that, Mr. Candela, then how do you plead to the state jail felony offense of theft of property greater than or equal to $2,500 but less than $30,000?
Guilty.
Are you pleading to that charge because you are guilty of committing that charge? Mr. Candela?
Yes.
Yeah, I sense some hesitancy in you. Do you understand the questions that I'm asking you?
Yes. Yes.
Okay, you understand that I'm asking you, are you guilty of committing this offense?
Yes.
Okay, and Mr. Gimbel, is there any objection to State's Exhibit 1?
No objection, Your Honor.
All right, State's Exhibit 1 is admitted into evidence. The court's going to accept the defendant's plea of guilt and take judicial notice of his judicial confession. Anything further from the state other than the summation of evidence?
No, Your Honor. I would note that the state is in compliance with victim notification. We sent out a victim impact statement and it has not been returned to our office.
Thank you, Mr. Wood. Anything further from the defendant, Mr. Gimbel?
Nothing further, Your Honor.
All right, Mr. Woodwike, will you give me a brief recitation of the facts that support the plea?
Judge, on or about 7/1/2019, Mr. Candela wrote a check to TL Thompson, I believe, for a 52-inch World Lawn zero-turn mower that was returned insufficient funds. This is a theft by check situation that our office went through our process, sent letters, received no response, issued a warrant. Mr. Candela was brought before this court. That's the situation.
Mr. Gimbel, any to that summation?
Nothing further from the bench, Judge.
All right, then based on the evidence presented to the court will follow the plea agreement in this case. The court hereby convicts Jose Carlos Candela of the charge of theft of property, $2,500 but less than $30,000, assesses his punishment at 2 years confinement in the state jail division of TDC. Court will suspend that sentence and place the defendant on community supervision for 2 years, orders him to pay restitution in the amount of $6,479.39. Court orders him to pay court costs of $290, reimbursement fees of $70, and attorney fee reimbursement of $500. Mr. Candela, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you step over to be fingerprinted with the deputy. After that, you need to speak with the representative from the probation department, and they'll give you more information about what you need to do when you're released.
Okay. Thank you.
Judge, also one more thing on, I believe, all of Mr. Gimbel's cases. They were sent to Mr. Gimbel. The state has not signed them. We will come to the courthouse as soon as we are finished with court and sign all those documents.
All right, thank you, Mr. White. Albert Chesney, CR 2150. All right, if one of you can give me the terms of the plea.
Plead guilty to the lesser included offense of theft of property, $2,500 to $30,000, punishment assessed at 6 months TDC and a fine of $2,500.
Does Mr. Chesney have any credit time?
He has 180 days credit.
And court cost?
$290, Judge. $20 reimbursement.
Is Mr. Chesney wouldn't be going to TDC today, would he?
Unlikely, Judge.
Because he's already served all.
Yes, Judge.
Does that mean that we can attempt to collect our attorney fees if he's actually not going to TDC? Do you know?
That would be my understanding, Judge.
Mr. Gimble, what'd you say?
That would be my understanding.
That the court could or could not assess attorney fees?
I would assume since he's being released, if in fact that, followed suit, he would be available to pay his fees and fines.
Mr. Wood, what's your opinion on that? Do you have one or?
Judge, I believe that is correct, considering he has time served. He's not actually being remanded to the custody of the Texas Department of Criminal Justice. I believe we could ask for reimbursement for that. I don't believe we caught that.
Okay. If we can have the judgment done and sent out to the jail, I'll call Mr. Chesney's case again in just a moment. But I would like to assess the attorney fees so that Mr. Chesney could reimburse the county.
Mr. Gimble, do you know what your fees would be?
500.
Okay, I will go speak with my legal assistant. We'll get that sent out, Judge.
Well, and also if there's any legal reason or prohibition for me doing that, I want you to let me know. Otherwise, I'd like to assess it on judgment.
Yes, Judge.
Okay. So you can have a seat, Mr. Chesney, and we'll call you back in just a moment. We're going to fix the paperwork and then we'll proceed with your case. Okay, sir?
Judge.
Kenneth Davis, CR 24/7. All right, what are the terms for Mr. Davis?
15 months confinement in TBC State Jail and a fine of $1,000 and $180 restitution.
And credit time?
267 days.
Mr. Davis wants to make sure that I get that on there, don't you, Mr. Davis?
Yes, sir.
Any reimbursement fees?
85.
80 or 85?
85.
85. And that's going to be on the charge of possession of controlled substance less than 1 gram?
Your Honor.
Okay. All right, Mr. Davis, if you'll raise your right hand, sir, I'd like to place you under oath. Mr. Davis, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down, Mr. Davis. You are Kenneth James Davis, is that correct?
Yes, sir.
And Mr. Davis, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Brent Gimble. Are you pleased with the representation of you?
Yes.
Did you say yes or I guess?
Yes, sir.
Yes, okay. Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
All right. Mr. Gimble, do you believe your client to be competent today?
I believe he is.
And you've explained to him his legal and personal rights?
Yes, I have, Judge.
And Mr. Davis, you've heard the plea agreement, which appears to be that you're going to plead guilty and the state's recommending to the court that your punishment be assessed at 15 months confinement in state jail, with you receiving the credit for all of the time that you've served on this case, which is 267 days. And you would also have a fine of $1,000. You'd be ordered to pay restitution of $180 and also reimbursement of $85. Is that your agreement today?
Yes, sir.
All right, and you're asking the court to approve that?
Yes, sir.
Okay, thank you, Mr. Davis. All right, Mr. Davis, the range of punishment for a state jail felony is confinement in the state jail division of TDC for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. Based on that range of punishment and the proposed plea agreement, the court would find that the plea agreement does fit within that legal range of punishment. So understanding that, Mr. Davis, how do you plead to the charge of possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
And Mr. Davis, are you pleading guilty to that charge because you are guilty of committing that charge?
Yes.
Has anyone threatened you or forced you to make you feel like you had to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Gimbel, any objection to state sworn?
No objection, Judge.
State sworn is admitted into evidence. The court takes judicial notice of Mr. Davis's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing further, Judge.
And Ms. Heisel, can you give me a brief summation of the facts supporting the plea?
Yes, Your Honor. Law enforcement was called out by people on a county road stating that there was a subject in the road, walking in front of cars, just acting very suspicious. Law enforcement went out and located who they later found to be Mr. Davis in that roadway. When they tried to approach him to do a welfare check on him, Mr. Davis ran onto some private property and hid behind a tractor. Law enforcement pursued him, placed him, detained him for his safety, checked the tractor and found a bag of meth sitting on the side of the tractor where Mr. Davis had been hiding. They asked him if it was his, and he denied possession or ownership. However, they asked him if they ran fingerprints on the baggie, if his fingerprints would be on it, and he conceded that yes, they would be. The lab came back at 0.93 grams of methamphetamine, Your Honor.
Mr. Gimbel, any objections to that summary?
Nothing to add, Judge.
All right. Based on the evidence presented to the court will follow the plea agreement in this case. Court convicts Mr. Davis of that charge, assesses his punishment at 15 months confinement in the state jail division of TDC, orders a $1,000 fine, $180 restitution, $85 reimbursement fee, and the court awards Mr. Davis 267 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Davis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of your sentence. Good luck to you, sir. I'm gonna have you step over to be fingerprinted with the bailiff.
Judge, who do we have at the jail that Miss Abney can send the paperwork to? Miss Burns, I believe, is there. I've told her to send her to her, but I don't believe Miss Patty is there. Is she?
No, she
Yeah. Rachel Matura.
Oh, it's okay. Well, I'll have her send it to Rachel then. Thank you.
All right, let's see. So is Miss Gutierrez made her way up yet?
I don't believe I have Gene Hill and Adrian Gutierrez, and neither of them have been brought up yet, Judge.
Hang on just a second. I'm sorry, Your Honor. I stepped away and wasn't paying attention. We've got a little bit of a holdup, but we do have Mr. Knoll ready. Can we see him while we get Mr. Gimbel's other clients up here?
Yes, ma'am.
Is that okay? Okay.
Yes, ma'am. All right, court call CR 20-112, State versus Dawn Lee Davis.
Afternoon, judges.
Good afternoon, Mr. Knoll. How are you, sir?
Pretty good.
All right, Ms. Davis is set for a docket call today.
Judge, in discussions, 2 emails back and forth with Mr. Woodwick, I think we have a plea. We do not have papers. What I was going to ask the court to do, the plea offer is for probation with Homeward Bound for drug treatment. She used to complete that program as a part of the probation. And I would ask the court if it would consider a PR bond pending, I guess, sentencing or plea and sentencing next time the court's available.
Well, what's the offer? I mean, what have y'all worked out?
It's 6 years probated for 5 with Homeward Bound as a condition of the probation.
And tell me what Homeward Bound is.
It's my understanding that that's a drug treatment program. Actually, my client's sister has been through that program, was successful in that program. We would ask the court to consider that. Obviously, the court would have to consider that. We thought we were going to have the application for that here. Somebody was supposed to bring it up. I don't think it's here yet. I wasn't here 2 minutes ago when I looked in the hall.
So you're asking me to give her a PR bond and then let her plead out later?
That would be it. I assume with conditions of bond, Your Honor.
And is that what it's wanting to?
Judge, I'm not sure where the disconnect is. We have extended an offer of probation. I don't know why we didn't do the paperwork such that we could plead today. Let me pull up. I don't know if we have any objection to a PR bond at this time.
The only way the court's going to entertain a PR bond under these circumstances is in conjunction with a waiver of jury trial. Because what I don't want to happen is let Miss Davis out on a PR bond and then her relapse and I've got to go find her and then she get another charge and I've got no post conviction or post or any type of deferred adjudication jurisdiction over her.
Judge, with the court, if I hand wrote, back in the old days, we used to do that. If I hand wrote a waiver of jury trial, and
If the state would be comfortable sending a waiver of jury trial that we would draft to Ms. Matura to have printed out so you and your client could go over that. If that's something the court would like to consider.
Well, I'm still waiting to hear from you two that that's your agreement. Right now, Mr. Nolan request, I want to know, state if you agree to a PR bond and conditions. I'm telling you the only thing I want included in that is a waiver of jury trial. If it's your case and you agree to a PR bond and you believe that she's going to be fine, then I'll let you two agree to that. But I want the jury trial to sweeten the deal in case she doesn't do what she's supposed to do when she's let out without the benefit of being on probation and a homeward bound program or anything else to try to keep her straight and clean.
Judge, I don't believe my client has a problem waiving the jury trial issue, so we would be willing to execute that. Obviously, if she was on pretrial release terms and didn't either show up for pretrial release or didn't appear at some point, then that would be yet another charge, and I think she understands that.
And she should already be on conditions of pretrial release, even though she's not on release. I believe that those should have already been ordered in her case.
I think so. That's correct, Judge. So if we get a waiver of jury trial, I think the state agrees otherwise.
Like I said, I don't have a problem if that's the offer is probation. And if we can't is there any reason we can't do the paperwork today?
Other than it getting here, probably not.
What does that mean other than what getting there?
The plea paperwork, we don't have the plea paperwork drawn.
Judge, if we could recall Ms. Davis's case, I'm sure I can talk to Ms. Abney. I think we could probably get that prepared. I don't see why we can't just resolve it today.
Okay, well, that's all obviously
that would be my preference as well. I don't know why we haven't prepared the paperwork already. I'll look into that and I'll get Ms. Abney to prepare that.
All right, that'll be plan A, and if for some reason we can't get it done, then the waiver of jury trial and pretrial release will be plan B.
That sounds good to me, Judge. Thank
So
you.
Ms. Davis, either way, you'll be getting out today. That's probably what you're waiting to hear.
Thank you, Judge.
You're welcome. Have a seat, and we'll be right back with you.
Yes, ma'am. And we do have the paperwork straightened out from Mr. Chesney.
All right, Mr. Chesney, you want to come on back up?
I think the judge needs to recall this after a slight correction.
All right. Did we get our paperwork fixed?
Yes, we did, Judge.
All right. So we're back on the record, CR 2150, State versus Albert Chesney. All right. And so now the judgment reflects attorney fees of $500.
A reimbursement fee of it was originally 20 and it's now 520.
Excellent. Okay. All right. All right. You're going to have to refresh my memory. Have we already started the plea process with him? Or did I ask these questions before we got going?
I think you caught the error when it got down to the reimbursement amount. We got down that far.
Okay. All right. Mr. Chesney, have I placed you under oath yet?
No, sorry.
Oh, okay. If you'll raise your right hand, I'm going to do so at this time. Mr. Chesney, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You can put your hand down. Mr. Chesney, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Brent Gamble. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Anything about the paperwork that you've read and signed today that you do not understand?
No, sir. I understand everything.
Is that your true and correct signature that appears throughout the documents?
Yes, sir.
And you only signed the documents once you understood what you were signing?
Yes, sir.
Mr. Gamble, do you believe Mr. Chesney to be competent today?
I believe he is, Your Honor.
And you've explained to him all of his legal and constitutional rights?
Yes, I have, Your Honor.
All right, Mr. Chesney, the range of punishment for a state jail felony offense, which is what the proposed plea agreement offers, is not less than 6 months or more than 2 years confinement in TDC State Jail Division and a fine not to exceed $10,000. From the proposed plea agreement, I see that that would fit within the legal range of punishment. Do you understand the legal range of punishment?
Yes, sir.
All right. Understanding that, how do you plead to the lesser included offense of theft of property greater than or equal to $2,500, but less than $30,000?
Guilty.
And Mr. Chesney, are you pleading guilty to that charge because you are in fact guilty of committing that charge?
Yes, sir.
Has anyone threatened or forced you to make you feel like you had to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Gamble, any objection to States 1?
No objection, Your Honor.
All right, States 1's admitted into evidence and the court takes judicial notice of Mr. Chesney's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing from the defense, Your Honor.
All right, and Ms. Heisel, will you bring me the brief summation of the facts to support the plea?
Yes, Your Honor. Mr. Chesney's mother went to the Grand Saline Police Department and made them aware that Mr. Chesney had borrowed her car some days ago and was refusing to return it. She showed the Grand Saline Police Department a series of text messages where over the last several days, she had told him that he needed to return the vehicle. He said he would, but then he didn't. Eventually, Mr. Chesney tells the mother to just report the car stolen, but not to tell the police it was him that took it. That way insurance will give her a rental car and then eventually buy her a new car. And mom shows the police all of these text messages. Mr. Chesney did end up returning the vehicle to a sibling in Fort Worth sometime after this. But at that point, the police report for the stolen car had already been entered.
Mr. Gimbel, any objection to that summation?
No objection, Judge.
All right. Based on the evidence presented to the court's going to approve the plea agreement in this case and follow it. Court hereby convicts Albert Chesney of the state jail felony offense of theft of property, $2,500 to $30,000. Court orders punishment at 6 months confinement in the state jail division of TDC. Court also orders a $2,500 fine. Court orders 180 days. I'm sorry, the court awards Mr. Chesney 180 days credit for the time that he has spent in jail towards his sentence in this cause. Court orders him to pay $290 court cost and reimbursement fees in the amount of $520. And there was no restitution, correct, Ms. Heisel?
No, Your Honor, the car was recovered in substantially the similar condition it was taken in.
Okay. All right. Mr. Chesney, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. In just a moment, I'm going to have you step over to be fingerprinted with the deputy. However, when you do get out, I'm going to order you to report to the Van Zandt County Courthouse on the 3rd floor to speak with the court collections officer so that you can make arrangements to pay your fines, court costs, and your attorney fees. Okay?
Judge, when would you like me to show up at the courthouse, today or?
If you get out today before 5 p.m., then come today. If you don't get out till late, then make contact first thing tomorrow. I don't know if anyone over there has a business card of Miss Pratt, but if you do, if you could give that to Mr. Chesney, I just need you to make arrangements so you can start discharging the money you owe. Otherwise, if you fail to do that, the court's going to issue a warrant for your arrest. Okay?
Yes, sir.
All right. All right, go ahead and go with the bailiff to be fingerprinted.
Okay, thank you, Judge.
You're welcome. All right, is this Mr. Hill?
Yes, it is, Your Honor.
All right, this is CR 21-104, Texas versus Gene T. Hill. We were set for, I think, arraignment and plea also. Is that
We're
correct?
set for a plea today, Your Honor.
Has Mr. Hill already been arraigned on his charges?
He has not been indicted, Judge.
Oh, he's not. All right, so this is a plea to an information.
He is, well, this is technically an arraignment / plea, but his agreement originally with the DA's office was to waive indictment and save the trouble of a full-blown indictment.
Okay, so it's a plea to an information?
Yes, Judge, it's a plea to an information.
Okay. All right, Mr. Hill, if you will raise your right hand, I'm going to place you under oath. Mr. Hill, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Hill, you can put your hand down. All right, you are Gene T. Hill, is that correct?
Yes, sir.
Mr. Hill, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Brand Gimbel. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand?
No, sir.
And throughout the documents where your signature appears, did you only sign there once you understood what you were reading?
Yes, sir.
And that is your true and correct signature throughout?
Yes, sir.
All right. And Mr. Hill, in this case, I'm understanding that you're wanting to waive your right to have the grand jury review your case and determine whether or not they would issue a true bill of indictment. Do you understand that in the state of Texas, anyone accused of a felony has an absolute right under the Constitution and the laws of this state to have that case presented to the grand jury? You understand that?
Sir.
In fact, no one can be charged with a felony unless the case first goes through the grand jury process. However, an accused and defendant such as yourself can waive the right to have the case presented to the grand jury. Is that what you're wanting to do today?
Yes, sir.
And why are you wanting to waive your right to the grand jury?
To speed up the process.
Okay. Has anyone threatened you, forced you, or made you feel like you have to waive your right to the grand jury process?
No, sir.
And are you making this decision of your own free will?
Yes, sir.
All right, court will approve the waiver of indictment, find that Mr. Hill has intentionally, knowingly, and voluntarily waived his right to a grand jury indictment in this case, and the court will allow the state to proceed on the information filed in this cause. Mr. Gimbel, do you believe Mr. Hill to be competent today?
I believe he is, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, I have, Your Honor.
And did you also speak to Mr. Hill about his rights regarding waiving grand jury, waiving indictment?
Yes, I did, Judge.
Okay. And you feel like he understands everything that you've explained to him?
I believe he did.
Okay. And what is the terms of the plea agreement between Mr. Hill and the state?
Judge, we are agreeing to proceed under section 1244A, the Texas Penal Code, punished to be assessed at 103 days in the county jail, credit for 103 days, a fine of $500.
That is our understanding of the agreement, Judge.
Court costs of $290, reimbursement of $15, court-appointed attorney's fees of $500.
And did you say 1244A or B?
A, Your Honor.
All right, Mr. Hill, you are charged by information with a state jail felony offense of unauthorized use of a vehicle. Under the plea agreement, you would be pleading guilty to that offense under the purview of section 1244A of the Texas Penal Code, which would mean that if the court approved the plea agreement, you would be pleading guilty and found guilty of a felony offense, a state jail felony offense, but you would be prosecuted as a misdemeanor. You understand that, sir?
Yes, sir.
You understand that if I approve this, you walk out today, convicted felon?
Yes, sir.
All right. And so punishment for a Class A misdemeanor under 1244A is convicted in the Van Zandt County Jail for a period not to exceed 1 year and a fine not to exceed $4,000. Based on that range of punishment and the proposed plea, the court would find that the plea agreement does fall within the legal range of punishment. Understanding all of that, Mr. Hill, how do you plead to unauthorized use of a vehicle?
Guilty.
And Mr. Hill, are you pleading guilty to that offense because you are guilty of committing that offense?
Yes, sir.
There was a little bit of hesitation there. And it's my job to detect you're guilty of committing unauthorized use of a motor vehicle.
Yes, sir.
Okay. All right. Court will accept the, well, Mr. Hill, let me ask you, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right. Court will accept the defendant's plea of guilt at this time, finds that it's intentionally, knowingly, and freely given by Mr. Hill. Mr. Gimbel, any objection to states one?
No objection, Your Honor.
All right. States one's admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further
No, Your Honor.
from the defense?
Nothing from the defense, Judge.
All right, then, Mr. Woodwike, if you can give me a brief summation of the facts.
Judge, on January 8th, the owner of the vehicle, a Stephen Smith, went to the sheriff's office, reported his car stolen. He gave it to a friend, Mr. Gene Hill. He wanted to sell the vehicle, but he needed to fix it first, so he gave it to Mr. Hill to use and to fix for a while. That was on December 9th. This is obviously a month later. Mr. Smith attempted to contact Mr. Hill on multiple occasions to get his car back, was unable. And then on January 17th, Mr. Hill was found at the Duke's gas station asleep at the pump inside the vehicle.
Mr. Gamble, any for that summation?
No objection. There's nothing to add, but just to clarify, the alleged or the victim in this matter did get custody or possession of the vehicle back.
He did. The vehicle was recovered in, again, substantially the same or similar condition as to when it was taken.
All right. Thank you, Mr. Gamble. All right, then based on the evidence presented to the court will follow the plea agreement in this case. The court hereby convicts Mr. Hill of unauthorized use of a vehicle under section 1244A of the Penal Code. Court assesses his punishment at 103 days confinement in the county jail, awards Mr. Hill 103 days credit towards his sentence for the time that he has spent in jail. Court assesses a $500 fine, $290 court cost, orders him to pay $500 towards attorney reimbursement to Van Zandt County, in addition to a $15 reimbursement fee. Mr. Hill, whenever you are let out, I'm going to order you to report to the Van Zandt County Courthouse as soon as practical so that you can speak with the court collection officer so you can make arrangements to discharge the monies that you owe. Your failure to do so will result in the court issuing a warrant for your arrest, and you'll end up right back in the same place. Do you understand?
Yes, sir, but how much time do I have? Because I have to go to a halfway house for 30 days until I discharge my parole.
Well, whenever you're released from custody. So if you're in
Okay.
say again. Yeah, whenever you're out of custody and you're no longer when you're free to move about, then you need to call up, and you can call up and make arrangement over the phone. Okay. All right. All right. So, Mr. Hill, I'm going to go ahead and order you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir. All right, is this Mr. Gutierrez?
Sir.
All right, CR 2168, State Adrian Gutierrez, set for arraignment today, Mr. Gimbel.
Yes, Your Honor, and I have just been notified by Mr. Gutierrez that he has retained his own private counsel. I have just not received a substitution of counsel notice yet, but we have received a copy of the indictment, and Mr. Gutierrez's name is spelled correctly, and I believe he understands the charges against him and would enter a plea of not guilty, but not wanting to overstep my bounds if he has retained other counsel at this time.
Well, let me look into the clerk's case. I'm not aware of that.
Mr. Gutierrez did notify me when we visited a couple of months ago that he was actively seeking other counsel to retain, but I had not received notice that he actually hired somebody.
Mr. Gutierrez, I don't want to talk about your case any more than to find out who did you hire?
I hired Adrian Crane.
Adrian Crane. And when did you hire Adrian Crane?
It's been about 2 weeks ago.
How come Mr. Crane's not here today?
He was unaware of this court appearance. He told me that he tried to get a hold of the courts and was got a answering service or something and wasn't able to get a hold of anybody.
For 2 weeks?
No, this was yesterday, I believe. he came to see me on Monday, and I retained him the week before, and I signed paperwork with him to, take over this case. And
Okay. All right, so this is how we're going to proceed, Mr. Gutierrez. Right now, the court does not recognize Mr. Crane as your attorney just because he hasn't filed in the necessary paperwork with the court to enter his appearance on your behalf. Once he does so, then the court can discharge Mr. Gimbel and you can proceed with the counsel, Mr. Crane, that you selected. But for purposes of today and until a time that I see a motion to substitute Mr. Crane for Mr. Gimbel, we're going to go ahead and move forward on the case. All right. Which all that means today is that Mr. Gimbel said that you and he have gone over the indictment, that you understand that you're charged with aggravated assault with a deadly weapon, that you understand the range of punishment is not less than 2 years or more than 20 years and a fine not to exceed $10,000. And Mr. Gimbel says that you've assured him that your name is spelled correctly in the indictment. So for the purposes of arraignment, it's really just to affix your identity and make sure that you understand the charges that are being brought against you. There's nothing more substantive than that. So I'm going to go ahead and enter your plea of not guilty into the record. All right. And I'm going to go ahead and set this for a pretrial hearing on June 15th. And so Mr. Crane can file a notice of appearance with the court. He'll also need to file a motion to substitute counsel and submit that to the court. And once I get that, then I will grant that without a hearing. And then Mr. Crane will be aware of the settings in this case and can make an appearance on your behalf. Okay.
Yeah, are these the only charges I'm being charged with?
This is the only one on my docket today. I'm not, I don't know if there's other charges that are pending at this time. I just know what's on my docket today.
Judge,
I believe there are 2 misdemeanors that are pending in county court.
Our office has 3 charges. This charge, a criminal trespass and a criminal mischief, which have been filed in the county court of law.
So does that make sense, Gutierrez? The state will say that there's a total of 3 charges. 2 are lesser charges, misdemeanor charges that are in another court. So if Mr. Crane is going to represent you on those, he'll need to make the same motions in that court. Okay.
Yes, sir.
All right. So you understand what I've told you today?
Yes, I do.
Okay, good. All right. So we'll see you back on June 15th. And if you speak with Mr. Crane, then Crane should know how to affix his representation of you. But if not, then you'll pass that information to him.
Okay, thank you.
All right. Have a good day, sir.
That is all the business I have today. May I be excused?
Just before you're excused, Mr. Gimbel, so I would just say, Mr. Gimbel, then, I probably wouldn't work on the case any longer. Maybe reach out to Mr. Crane and determine if that is in fact the case. And if it is, then just go ahead and start preparing your bill. And then if you don't receive notice of that or you receive information different from Mr. Crane, then I want you to contact Ms. Taberham and let us know.
Will do, Judge, and I do have received all the discovery in Mr. Gutierrez's matter, and be happy to provide that if here from Mr. Crane.
Okay, all right. Thank you, Mr. Gimbel. I appreciate it. Yes, you may be. Have a good day, sir.
Thank you, Judge.
Mr. Bond.
All right, this is cause number CR 19-180, CR 398, State versus Joshua McMartin. We're here today on motion to revoke and docket call, I believe.
Yeah, Judge, I'm pleased to announce that we have worked out a plea agreement. I do have the plea paperwork. My client wants to go over everything with me one more time. I was hoping also to get paid. So I was hoping maybe you could give me a plea date on this case.
I thought that's what we were doing today. No?
Yeah, I'm asking for not a long reset to set this for a plea. And I don't think the state's opposed to that.
Judge, Mr. Steele requested that. I don't see a reason specifically why we cannot reset. A lot of our negotiations regarding Mr. Martin revolve around the jail wants to keep, if the plea is for time, and I think the jail's intention is to, at least for some period of time, keep Mr. Martin in our jail because he is quite the asset to Van Zandt County while in the jail. They've requested this deal, and this, obviously the DA's office is working with the jail and Mr. Steele to work out a resolution that everyone is happy with in this case. I don't see a reason why we cannot reset for a short period of time for a plea.
Can I get somebody from the jail staff to tell me that? Because here's my concern. It's about $35 a day for taxpayers.
Yes, Judge.
If I can have somebody from the jail staff tell me that, and it's not that I don't believe you, Mr. Woodwhack, I just, before I reset, and I've looked at the docketing in this case, and we've been set numerous times on this case. And so that is my concern, is that we're just continuing to pay to house Mr. Martin. And if he's providing services that are offsetting the cost that the taxpayers are incurring to keep him in there, then maybe it is financially better for the jail to do that. But I would like to hear from someone who can validate that for me.
And Judge, he was on probation, but the new case, that case is not very old. He hasn't had very many resets on the new case.
Yeah, one is a motion to revoke, and one is it's the third setting on the new case. But Deputy Ragsdale, if we could get Lieutenant Harrelson or perhaps someone from jail administration to step in the courtroom.
Mr. Woodwhack, I am actually working on that right now. Ms. Harrelson is not in her office, but I've sent her a text and I've sent a runner to find her as well. So she should be here shortly.
Judge, if we could just recall this, I have no doubt that they will confirm all these things.
That's fine. And maybe it's just, is it my confusion? I thought we were set for plea today. That's my.
Judge, I believe we were set for a plea today. We've provided the paperwork. Mr. Martin wants to go over the paperwork with his attorney for some more time. All those things are between Mr. Steele and Mr. Martin, but state is not opposed to a reset at this time.
Yeah, Judge, just so what I understood was last time we were in front of you, we did not have a deal worked out. And so you set it for today to plea or be set for a contested hearing. We don't need a contested hearing. And I think we do have a plea worked out. I was just asking for a little more time.
Hang on. I think the issue is today was to plea or to have a contested hearing, not to set for a contested hearing.
Yes,
Today was either plea or we go to a hearing and I decide the case. That's my recollection.
Okay.
And so that's why I'm saying either we got a plea or we don't. And if we don't, then today was to put on the state's evidence on a motion to revoke and go forward. So now you're hitting me with this additional information about the jail. So I want to hear that out, but I just want you to know where I'm coming from.
Yes, sir.
This was my recollection, and this is why I'm asking these questions.
Joe, Judge, I've been notified, Deputy Carter is dealing with something downstairs, but he will come upstairs in person in the district courtroom. He is the one who's actually requesting some of this is Mr. Carter. So hopefully he will be along shortly.
And Lieutenant Harrelson is here, Your Honor. She's not aware of the questions, but she is here now.
Afternoon, Judge.
Step on up to the firing squad.
Okay.
All right, so I'm going to try to repeat what's been told to me, and you all correct me if I'm wrong. So Mr. Martin was set on today's docket for either a resolution of his case one of two ways. One, he was either going to accept the plea agreement of the state and resolve both of his cases, or we were going to hear the motion to revoke in one of his cases. Neither one of those things are happening because Mr. Steele and Mr. Woodwhack are asking that neither one of those things happen. But they've both indicated to me that it's the jail's position, your position, that the court should grant Mr. Martin more time for him to review the case and basically just reset the case. And it's going to result in a resetting of at least 60 days. My concern was that's about whatever our cost is per inmate per, whether they're housed in or out. And so I just kind of flat based that at $35. So my concern was $35 a day times 60. And they've indicated to me that Mr. Martin is a good trustee, and he's providing services to the jail. And so I said I wanted to hear from the jail that is in fact the case, that the jail, if I were to grant their request today and reset the case an additional 2 months, that it's what the jail is wanting. Because I know that we got overcrowding in the jail, and I know the costs associated with it. And so I was hoping to hear from you or someone else in the jail that would say, no, Judge, we think that this is appropriate, and then tell me why it's appropriate.
I did send an email to Ms. Curry outlining everything that Mr. Martin has accomplished for us since he's been in a trustee position. And it kind of put the dollar amount as to the things that he's done. He has rebuilt offices. I'm not talking about a little touch-up paint. He's done some big work for us over here. So
Well, I don't have that email, so kind of just tell me what kind of outline for me if you can.
Can I pull it up?
Yes, ma'am.
So that
Sure. Yeah, if you can just tell me, then that'd be good enough, because otherwise I got to go take a recess and get that email.
I'm trying to add this up, Judge. I'm sorry.
Okay. And you can just give me a ballparks.
Probably close to about $25,000 worth of work. That's on the low end.
Okay. All right. Thank you. That's all I needed.
Thank you.
All right. So what I'll do is I will reset this. We can reset it sooner than the next contested docket would be June 29th.
June 29th is fine with me, Judge.
Now, if I set it on June 29th, it's going to be the same setting today. It's either he's going to plead guilty or we're going to have a contested hearing.
Yes, sir, Judge.
Set it for a contested hearing, not come in and ask for an additional 30 days. There's got to be a resolution to it. I don't want to Shawshank anybody.
I totally understand, and we'll get this case done that day, one way or another.
All right, so we're going to reset Mr. Martin then on his motion to revoke on June 29th, and also for final docket call on his DWI third or more CR 2398, same date. Mr. Martin, thank you for the work that you're doing on behalf of the citizens while you're incarcerated. We appreciate it.
Yes, sir. Thank you, Judge.
You're welcome.
Judge, that's all I have on that one. I have one other person on your docket today.
Okay, give Mr. Martin his yellow copy, and then the court will retain the white copy, and then we'll call your next case.
Yes, sir. I just need a case.
Got 19-00180. 20-00.
Okay.
All right, is Mr. Groom, James Cody Gray?
Judge, I sent a doctor's note to Patty earlier today, and I've got a copy of the doctor's note with me. He's had a fever, went and saw a doctor. Doctor said shouldn't have contact with anybody till May 3rd. So however the court wants to treat that,
What does that mean though?
that he's sick, and I have a doctor's note saying that he's sick. I guess I'm asking for a reset based upon the doctor's note.
Does it say he has COVID, or what does it mean? It shouldn't have contact?
No, I don't think I think he was tested for COVID. Patty has a copy of the doctor's note, but it basically says James Gray is excused from work due to illness for the following dates, April 28th to May 3rd, 2021. That's what the doctor's note says, and it's from Invicta Family Healthcare Clinic in Terrell, Texas, from a Dr. Ida Mudia.
That sounds insufficient to me. It doesn't say what he's sick of. It doesn't say it doesn't say he shouldn't be around people. It just says he shouldn't go to work.
Yeah.
That could mean he's got diarrhea. That could mean a lot of things. So he was set to plead today, wasn't he?
Yes, Judge.
He was set to plead a time.
Yes, we worked out a deal where he was going to plead a time.
I think I may know what his illness is.
Sure, Judge. Would you like me to get a more specific or a better doctor's letter?
No, I think the time is coming on for that. So I'm not going to accept the doctor's note as an excuse from court. So I'm gonna call his name.
You froze up, Judge.
I froze up. Can anyone see?
Everybody froze up but us. Judge, if you can hear me, I'm gonna step out of this and come back.
Judge, we can hear you. I think it's the jail internet again.
Okay. Well, we could hear Aaron fine.
Yes, Judge, but their video is frozen for me.
Yeah, mine as well.
Your Honor, can you hear us?
I can't hear you.
Very good. I think we're back to live now.
All right, I'm gonna wait for that, whatever that copier or printer is, to stop. All right, so Mr. Steele, what I was saying is I'm not going to accept the doctor's note as an excuse for missing court when he's supposed to go into custody. It's not very detailed, not sufficient. So I'm gonna call his name, and if he's not here to do his deal, then I'm just gonna issue a warrant for his arrest.
All right, Judge.
So do you believe that you can get him to court today?
He said he was sick. He saw a doctor. All I can do is make a phone call.
Okay. All right, so the court will have his name called. If he doesn't appear, then the court's going to issue a judgment nisi and alias capias. And so you,
Yes, Judge. I suppose if I find him, I could bring him in on a day that you're doing docket, and we could do the plea.
yeah, you can just have him turn himself in on the warrant, and then once he gets in, then you just call the coordinator, and we can get you set for a plea.
Yes, sir. Thank you, Judge.
You're welcome, Mr. Steele. Free to go.
Excuse. Yeah, thank you.
Yes, sir. And I will need someone at one of the bailiffs or deputies to call James Cody Gray's name 3 times, loudly and distinctly, outside the jailhouse courtroom at some point this afternoon.
Yes, sir. Mr. Knoll, are you ready yet? Okay, still working on that.
Do we have Liza Langley yet?
Your Honor, Mr. Schmidt went and visited with her and got,
Waiver?
yes, sir.
Okay, what's the pretrial date on that?
It's May 11th, Your Honor.
May
Yes.
11th?
Thank you, Ms. Heisel.
May 11th?
That's what Mr. Schmidt emailed us.
Oh, that's, yeah, we're already over capacity that day. All right, so I guess we're stuck with it now. We'll just need to make sure that we don't set anything else in May. All right, Liza Langley set for pretrial on May 11th. What about Mr. Schmidt's client?
Mr. Jonathan Spencer,
Yes.
he is here. Mr. Spencer, come on up, sir.
All right, I'm trying to find. Oh, yes. Okay, yes, that's why you're not listed. All right, this is CR 93, State versus Jonathan Spencer, set on arraignment today. And we also had him on status to hire an attorney. And Mr. Bronchman, are you here for purposes of counsel?
Yes, Judge. I was retained just before lunch, and we filed our e-filed our letter of representation. It's been e-filed but not accepted by the clerk yet. So that's, it was just filed an hour or so ago. We literally just got retained right before lunch. So, but nonetheless, I do have a copy of the indictment and I'm prepared to go forward with the arraignment, which I intend to waive, obviously.
Okay, well, let me do this. Let me, just because Mr. Spencer is where he's at, let me see if I can pull up the indictment for you so that he can go over it at the same time. So we can, unless you've already gone over it with him.
Judge, I've discussed the indictment with Mr. Spencer. May I ask him a quick question? Save us some time.
Yes, go ahead.
Jonathan, you understand what you're charged with on this failure to appear or bail jumping, correct?
Yes, sir.
And your name is spelled correctly, Johnathan, his first name?
Oh, yeah.
Yeah, that's what I thought. Judge, we'd ask the court to make a trial amendment to correct the name to Jonathan with an O-N as opposed to an A-N in both the body and style of the indictment.
And that's at the end, TH, so it's John, and then ATHON. Is that correct?
That's correct, Your Honor.
All right. Court will grant the oral trial amendment to amend the indictment to reflect the true and correct name of the spelling of Jonathan Spencer to JOHNATHON.
Thank you, Judge. And with that, may I proceed?
Yes, sir.
Judge, his name is now spelled correctly on the indictment. He does understand the nature of the charge. We'd waive the formal reading of the indictment, enter a plea of not guilty. Judge, I know I do. I will be at the jail docket on May the 27th at 1:30, and I was going to see if we could perhaps set this for a pretrial on that day.
I'm going to have to look because we're over capacity for that day as well. Give me a second. Let me see how
Sure.
On the jail docket that day. If that day is not available, what about June 1st?
I have just a moment, Your Honor. I'm downstairs in my conference room, so I'm looking at my June 1st, I'm scheduled to be, I have some discovery status conferences in the 392nd at 1:30. Those shouldn't last very long. So, I mean, I could get up to the jail. It just may be about 2:30 or so before I got there.
Let's do that. I'm fine with you being a little bit late. I'll mark it. Let's just set it for 2:30. We'll just set it for 2:30.
Okay.
If you're a little bit late, that's fine as well.
Okay.
So we'll set it for pretrial on June 1st at 2:30.
Judge, actually, while we're here, this arises from a case CR 18-00224, which is an allegation of engaging in organized criminal activity that I was also retained on. That case is pending in Judge Winter's court. Apparently, you voluntarily recused yourself because the date of alleged offense is in 2017. That case was scheduled for status to hire attorney on Monday. I've spoken with Miss Anthony and she's taken it off that docket and we're looking at new dates. I don't know the arrangement. Do we want to continue on this dual track or do you want to transfer this to that court since they've been handling. What happened is Miss Beasley withdrew from that case. And so he's been without an attorney. So, I mean, we can go on in both courts, or if y'all want to consolidate, obviously we can't consolidate back to your court, but if you want to transfer this to his court, if he accepts it, I have no objection if Mr. Spencer doesn't, so we can, they can track together.
Right. I know that I would not recuse or be disqualified on this case. And it's not my policy to just unilaterally send cases to Judge Winters. So
Sure.
I think the better course of action would be if you wanted them consolidated for judicial efficiency, is if you filed a motion to transfer to the county court of law. I would grant that from my end, but then that would allow Judge Winters to be able to decide whether he wants to accept the case or not. That would be the way I would want to handle it, rather than me just, hey, Judge, take this one.
And Judge, really, actually, I probably overstepped. I probably need to speak with the DA first and see if they even agree to that. So I'll get with them. And no objection?
No.
Okay, then I'll get a motion filed, Judge.
And then I'll review that, and I would grant that without hearing.
Okay, very good. And Jonathan, I'll be up to see you next Tuesday or Wednesday so we can go over everything, okay?
Okay.
Thank you.
All right, then, if I haven't said already, the court enters Mr. Spencer's plea of not guilty into the record, sets for pretrial June 1st at 2:30. If the defendant files the motion to transfer and the court grants that, then obviously we will not need that hearing.
Thank you very much, Your Honor.
Thank you, Mr. Schmidt.
May I be excused?
Yes, sir.
All right.
All right, who do we have next in the jail?
Your Honor, we have Ms. Basham for Ms. Ann Thompson.
All right, this is CR 15447, State versus Angelina Annette Basham. Believe that we're set for plea today, Ms. Thompson, is that right?
That is correct, Your Honor.
All right, can someone tell me the terms of the plea agreement?
Judge, if you could just give me 1 second to pull it. The paperwork is at the jail, so let me pull up my copy. Your Honor, the state is going to agree upon a plea of true to 4 years confinement in the Texas Department of Criminal Justice. There's a balance of financials, which is $2,500 on her fine, $50 on her court costs, and she is going to have 491 days. Is that right? Yeah, 491 days credit.
And Ms. Thompson, is your client going to be pleading true to all counts?
Yes, Your Honor.
Okay. All right, Ms. Basham, if you will, raise your right hand. I'm going to place you under oath. Other right hand. There you go. Ms. Basham, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Make sure you speak up loudly for me so my court reporter can hear you. Ms. Basham, are you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you?
Sir?
Are you pleased with Ms. Thompson and her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed that you do not understand?
No, sir, I understand.
All right, the state has filed its amended motion to revoke your community supervision, and they filed that on March 30th of 2021. Have you had an opportunity to review this document with your attorney, Ms. Thompson?
Yes, sir.
And it appears that on April 25th, 2017, you appeared before this court. You pled guilty to the third-degree felony offense of driving while intoxicated, third or more. Court heard the evidence, assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice, but the court later suspended that sentence and placed you on community supervision for 10 years, also assessed a $2,500 fine. It was during this term that the state filed this amended motion to revoke, and they have alleged, as you see here on the screen, counts 1, count 2, those being the sole 2 counts in your motion. Ms. Basham, I'm going to ask you at this time, how do you plead to counts 1 and 2?
Guilty.
And Ms. Thompson, did your client waive the formal reading of the state's motion?
Yes, we do, Your Honor.
Ms. Basham, your plea would either have to be that to the court that these counts are either true or not true. So rather than guilty. So is count 1 and count 2 true or not true?
True.
Okay. And Ms. Basham, are you telling me that those counts are true because in fact they are true and for no other reason? You're not just telling me they're true so you can get a certain plea agreement?
No, sir, I'm telling you that they're true.
Okay. And has anyone threatened you or forced you to make you feel like you needed to plead true to these allegations?
No, sir.
All right. The court will accept Ms. Basham's plea of true to counts 1 and 2. Ms. Thompson, is there any objection to State's Exhibit A, the defendant's waiver of rights, a plea of true?
No, Your Honor, we have no objection.
All right. State's Exhibit A is admitted into evidence, and the court takes judicial notice of Ms. Basham's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right. Then based on the evidence presented to the court's going to find that Ms. Basham has violated the terms and conditions of her community supervision. Court having found counts 1 and 2 to be true, the court revokes her community supervision, assesses her punishment at 4 years confinement in the Texas Department of Criminal Justice. Court orders her to pay the balance of her financial obligations. The court does award Ms. Basham 491 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Basham, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Ms. Basham, when you are released from TDC, it's very important that you report to the courthouse so that you can contact the court compliance officer so that you can make arrangements to pay off the fines and fees that you owe. Your failure to do so is going to put you into a system which will end up having a warrant issued for your arrest. Okay, so as soon as you get out, just come up to the courthouse and speak with the court's collection officer. Do you understand?
Yes, sir.
All right, good luck to you, Ms. Basham. I'm gonna have you go with the deputy to be fingerprinted.
Your Honor, I think she still does need her thumbprint on the paperwork.
Yes, that's what the deputy's doing right now. Thank you, Ms.
Okay, thank you, Your Honor.
You're welcome. Is that all you have, Ms. Thompson?
Yes, sir. May I be excused?
Yes, ma'am. Have a good day.
You too, sir.
All right, are we about ready? I see that I've got some paperwork on Miss Dawn Lee Davis.
No, Your Honor, she and Mr. Knoll are just now stepping out to go over the revisions.
Okay, that's fine.
We do have Mr. Stevens here.
Did you just get there?
He's had time to go over his paperwork.
Good. I was saying if he was just strolling in, I was gonna take an hour recess. But if he's been working, let's keep him moving.
There you go, Judge.
CR 14-220, State versus Oscar Heredia. Mr. Heredia is here on a hearing on his motion to revoke. Is that correct, Mr. Stevens?
That is correct, Your Honor. And if I may advise the court, I was appointed about a month ago. And when I was appointed, he was in the El Paso jail. I didn't realize that he was now in our jail until actually yesterday. And we visited about what's going on, but I don't really have an announcement or anything for the court because I just met him for the first time.
And repeat that last part. You kind of
I don't really have an announcement for the court because I just met with him for the first time.
Okay. Has the state?
I haven't seen the motion to revoke or anything.
Okay. Has the state extended an offer yet to Mr. Heredia?
No, Your Honor.
Judge, I don't believe that we were aware that Mr. Stevens had been appointed. I'm looking at the case. His name is not yet on it. I will add it and release all of that to him at this point.
Okay. Give me just a moment. before I reset the case, what I'm going to do is I'm going to have displayed his motion to revoke so that he has the benefit of at least seeing it.
Yes, sir.
All right, so it looks like Mr. Heredia is on a straight probation for second-degree felony possession of controlled substance, penalty group 2, 4 grams to 400 grams. And the negotiated sentence was a 10 pro 5 with a $2,000 fine. So, all right. So the court will grant Mr. Stevens' request for additional time. There being no objection by the state. Today is the 29th. Next available time we'll have will be June 1st. Are you available on that date, Mr. Stevens? That's a jail only date. So it'd be in the afternoon only.
I am, Judge. I've got 3 cases in the 392nd, but nothing on my book here. If they're going to be real quick in the 392nd.
Is that in the afternoon?
Yes, sir, it is.
Okay, let's set Mr. Heredia then for June 1st. And if nothing is resolved by then we'll set him for a contested docket later that month.
Yes, sir.
And Mr. Woodwike, you said you're gonna allow, you're gonna hook Mr. Stevens up to the discovery portal. And
Yes, Judge.
And you'll extend an offer to him, perhaps?
Yes, Judge. I just opened up discovery for Mr. Stevens on the online portal for the motion to revoke, and I will get in contact with him and we will discuss this case.
All right, thank you, Mr. Woodwike. All right, Mr. Heredia, we'll see you back on June 1st.
Hey, Tyler, can you hear me?
Yes, sir.
Are you going to be around tomorrow?
We've got grand jury, so I'll be here. I just don't know if I will be available.
All right, I'll get it for you next week.
Yes, Judge. I mean,
Mr.
yes,
Stevens, Mr. Stevens, do you want me to order him to be available? What time you want to meet with him?
Oh, Judge, how about 7 o'clock Friday morning? How about that?
All right, so hey, send over a proposed order. I'll get that done.
There you go, Judge.
All right.
Judge McKee said hi to you.
Who did?
Judge McKee, I told him what I was heading. Tell you hi.
Hey, tell him you're going to come by and see me first on June 1st, and then you'll be over at his court right when you're done with me. And then you tell him I said hello.
No, really, I'll do that. Seriously.
Okay.
I'll tell you.
All right.
Thank you, Judge.
Thanks.
Your Honor, we do have Mr. Booker here. Mr. Null's still working on his paperwork, but we've got Mr. Booker available.
Okay. The CR 105 State versus Christopher Glenn Booker. All right, Mr. Booker, we're having a hearing today on your motion to revoke. Do you have an attorney yet, or are you going to hire an attorney?
Yes, sir. I'm a hired attorney.
Who do you plan on hiring and when?
Deborah Beasley. It'll probably be this upcoming Friday.
This upcoming Friday?
Not tomorrow, but next week, Friday.
A week from Friday. Do you feel fairly confident that you're going to be able to hire her?
Yes, sir.
Okay, because what I don't want to do is I don't want to leave you sitting over there without an attorney. Okay, so I'll, if you're telling me you're going to hire Miss Beasley, then I want you to be able to hire the person you want. And I'm going to give you that time. I just wanted to make sure that,
Yes, sir.
reasonably certain to happen. So, all right. So what I'm going to do is I'll reset you, Mr. Booker, for June 1st. And that'll give you time to get Miss Beasley hired and give her time to speak with the state about your case. Okay. If you'll just sign that form there with the deputy, and we're going to give you a copy of that. And it's just going to give you the next day that we're going to take up your case.
And now we wait.
Okay, we'll stand in recess until Mr. Knoll has an opportunity to go over the paperwork. And I just want to tell Ms. Abney, thank you for getting the plea paperwork done on short notice. Do appreciate it.
Judge, I'm not sure she's listening, but I will definitely pass that along.
You can tell her you took all the credit.
I always do.
All right, I'll be back in a minute.
said.
All right. Deputy McLeish, if you can unmute the device. Click that with your thumb there. And all right, Mr. Knoll, Miss Davis, are we ready?
We are, Your Honor.
All right, this is cause number CR 20-112, State of Texas versus Dawn Lee Davis. Miss Davis, if you'll raise your right hand, please. Miss Davis, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, can you put your hand down? All right, Miss Davis, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand?
No, sir.
Is it true that your signature appears throughout the documents, that it's your true and correct signature, and that you only signed once you understood everything in the document?
Yes, sir.
All right. Mr. Knoll, do you believe Ms. Davis to be competent today?
I do, Your Honor. In regards to the documents, she didn't have any glasses, so I read over them. That's probably what took a little longer than maybe.
Okay. Well, I appreciate your assistance on that. And you've explained to her her legal and constitutional rights and everything contained in the plea agreement?
I did, Your Honor.
Okay. And do you feel like she understood everything that she reviewed and signed?
I believe she did.
All right, Ms. Davis, you are charged by indictment with a second-degree felony offense of possession of controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. That carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. It appears to me that the plea agreement in your case with the state of Texas is that you're going to plead guilty to that offense, and the state's going to recommend to the court that your punishment be assessed at 6 years confinement in the Texas Department of Criminal Justice. And their recommendation is also that that sentence be suspended and you be placed on community supervision or probation for 5 years, that you receive a $2,500 fine, restitution of $180, court costs of $290, and that you pay reimbursement fees of $655. Is that your understanding of the plea agreement, Ms. Davis?
Yes, sir.
And that's what you're asking the court to approve today?
Yes, sir.
All right, Ms. Davis, understanding the range of punishment, how do you plead to that second-degree felony offense?
I plead guilty.
And are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Knoll, any objection to states 1?
No objection, Judge, but just as a correction, I guess, on the punishment end of it, she's also to enter the homeward bound drug program as soon as possible, and we did get all of the information to send to homeward bound. I've instructed her to get that filled in, make a copy, and get it to probation, who she'll meet with tomorrow at 10 o'clock.
All right, I don't see that in the judgment. Is that located somewhere else in the agreement?
Judge, I believe that's a condition of probation. It's likely in there.
Judge, I have written it in on the judgment, because that was a part of the plea agreement. It was either this program or another program.
Okay, it's just not, so, and I don't have the conditions of community supervision. So, Ms. Davis, have you reviewed the conditions of community supervision?
Yes, sir.
Do you understand what Mr. Knoll is saying in that a condition of your agreement with the state here is that you're going to enter into that homeward bound program?
Yes, sir.
And do you understand that if that is a condition of your community supervision, that if you do not follow that condition, that could be considered a violation of your community supervision?
Yes, sir. I understand.
Okay. All right, let's see. The court submitted State's Exhibit 1. Court's taking judicial notice of Ms. Davis's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, I'm gonna take just a second to review the evidence. All right, Ms. Davis, based on the court's review of the evidence, I do find there is enough evidence to convict you of this offense. The court will follow the plea agreement you've reached with the state. Court convicts you of the second-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams. Court assesses your sentence at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence, place you on community supervision for 5 years. Court assesses a $2,500 fine, orders you to pay restitution of $180, $290 court cost, and orders you to reimburse Van Zandt County $655 in this case. Ms. Davis, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. Need you to step over to be fingerprinted with the bailiff. After that, you need to speak with the representative from the probation department, and they'll give you more information on what to do upon being released.
Thank you.
Good luck to you.
Ms. Davis, come back here with me, please.
Thank you, Judge. I think that's it.
All right, thank you, Mr. Knoll.
Your Honor, is there anything else we can do for you here at the jail before we sign out?
I don't believe so. Oh, yes, there is. Thank you, Stella. I do need the name James Cody Gray called loudly, distinctly 3 times at the door of the jail courtroom.
That is, the jail, that has already been done, sir.
Okay, was there any response?
No response, Your Honor.
All right, court having called the name James Cody Gray in CR 17-147, court finds that Mr. Gray did not appear as ordered. He's not present in this courtroom or at the jail court. Name has been called loudly and distinctly 3 times with no response. Court hereby issues a judgment nisi and alias capias in this cause. Thank you, Mr. Ragsdale. Appreciate your help.
Yeah, anytime, Your Honor.
Thank you, Deputy McLeish. Appreciate your help.
Thank you, Your Honor. It's always a pleasure.
Thank you, Deputy Aaron.
See you, Tyler.